seated.
Judicial independence allows judges to rule on cases without fear or worry on balancing favoritism. According to the ancient Greek philosopher Socrates, 4 things belong to a judge: to hear courteously, to answer wisely, to consider soberly, and to decide impartially. In Canada, judicial independence is enshrined in the Constitution Act of 1867 to protect the courts and the citizens they serve. Judges must be independent and be seen to be independent to maintain trust in the rule of law and the democratic system.
I, Richard Wagner, do solemnly and sincerely promise and swear.
The Chief Justice, the Governor General.
Chief Justice Richard Wagner was appointed to the Supreme Court in 2012 and has served as Chief Justice since 2017.
As we open this new judicial year, let us once more affirm the principles that have guided this court since 1875. The rule of law, judicial independence, and equal access to justice.
There are 3 branches of power in Canada: the legislative branch, which creates laws; the executive branch, which administers and enforces those laws; and the judiciary, which interprets and applies the law to administer justice. The judicial branch manages its own administration to further strengthen its independence from the other 2 branches of power.
Show us why the finding of fact was totally unfounded on the evidence, not that you disagree with it. We know you disagree with it.
Former Supreme Court Justice Beverly McLaughlin served as Chief Justice on the High Court from 2000 to 2017.
If judges are beholden to either the legislative branch or the executive branch, or seen to be in the pocket of the legislative or executive, people lose confidence in the courts. The courts have to be impartial, and for that reason they have to be completely independent of these other branches of government and seen to be independent. And we have this long tradition in Canada of such independence. So the Prime Minister or Cabinet Minister would never talk to a judge on the Supreme Court or any other court about how a case should be decided, for example. And that has been preserved. Even in the makeup of our bench on the Supreme Court of Canada, we've never allowed political considerations in Canada to govern or to determine who would be the next justice to be named as a replacement, for example, to the court. We keep politics out of the court in the Canadian tradition.
Former Prime Minister and Justice Minister Kim Campbell.
Well, in theory, the Supreme Court is entirely independent. It is, of course, appointed by the cabinet, by the Prime Minister, nominated by Prime Minister, appointed by cabinet. And so, you might think that it would be a reflection of the thinking of the ruling party of the day. I've, always felt prepared to accept the court's decisions. But some of them were controversial, particularly decisions based on, Aboriginal rights. These were things that, of course, had become part of the new Constitution when it was patriated, the Section 35, etc. So for a lot of people, the court's jurisprudence in that area was new and maybe a little shocking or controversial. But I don't recall ever feeling that the court did something that made me question its credibility or its capacity to make those decisions.
Frank Iacobucci retired as a justice of the Supreme Court in 2004.
There's judicial independence and judicial impartiality. Judicial independence is crucial to a democracy. If the judges are in the pockets of politicians, there's no democracy. If the civil service is corrupt, there's no democracy. But the corruption in the court is just very, very severe in its consequences in terms of a democracy. The judiciary doesn't have an army behind it, doesn't have a financial bank behind it. It has only its legitimacy, and independence is part of that legitimacy, because people will accept it if they say, I can go to the court I may not agree with their decision, but I do agree that they did this honestly, with integrity, and not with any outside influence.
Des conseils indépendants, et comme je viens de dire, nous avons agi selon ces conseils.
Judicial independence of the Supreme Court was tested in 2014. Former Prime Minister Stephen Harper publicly suggested that then Chief Justice Beverly McLaughlin acted improperly over the appointment of Marc Nadon to the Supreme Court. Marc Nadon's appointment to the Supreme Court was challenged by a Quebec lawyer who said Nadon did not meet the criteria to be a justice from Quebec. After much debate, the federal government sent a reference question to the Supreme Court on the Nadon affair. Author and law professor Adam Dodek.
In a 6-1 judgment, the court ruled that Justice Nadon did not meet the qualifications because he wasn't a judge from a court in Quebec, and he did not meet the requirement, the tenure requirement at the bar, because he was no longer a member of the bar. That's interesting. So they invalidated his appointment, and he never took his seat on the Supreme Court, and he went back to the Federal Court of Appeal.
Harper's actions led to an investigation by the Geneva-based International Commission of Jurists at the request of a group of Canadian lawyers and academics to investigate. The commission found, quote, "Such public criticism could only have a negative impact on public confidence in the judicial system and in the moral authority and integrity of the judiciary, and thereby on the independence of the judiciary in Canada."
The Honourable Leader of the Opposition.
On Parliament Hill, then Opposition Leader Tom Mulcair called on the Prime Minister to apologize.
11 former presidents of the Canadian Bar Association have just written an open letter in which they say that the Prime Minister's disrespect for the Supreme Court harms the very workings of our constitutional system of government. It's also unprecedented. Will the Prime Minister apologize to the Chief Justice?
There's a long tradition that judges don't answer critiques, that they don't speak out in self-defense if they've been criticized. And I believe in that tradition in the normal course. The Prime Minister accused me of improperly interfering with the appointment of a candidate, of a fine person. I had not improperly interfered. And I felt that it was very important to the public that the facts of that case, of what I had done or had not done, be before the public so the public could judge. And so I decided to issue a very short press release. Ultimately, many bar associations and lawyers groups came to my defense, and I think the public confidence in the court's independence and in the behavior of their Chief Justice was vindicated.
5 years later, in 2019, Chief Justice Richard Wagner and former Justice Minister David Lametti signed an accord to recognize and reinforce the independence of the Supreme Court of Canada. McGill University political science professor Christopher Manfredi argues public perception of the court and societal behavior may impact that independence.
They do have to worry about public reactions to their decisions. I'll give you an example. The Sharp decision around child pornography, when the British Columbia Court of Appeal declared Canada's child pornography laws unconstitutional, and that came up to the court. I think the court had a very difficult political decision to make. It could also declare those laws unconstitutional, but I think it knew that it would provoke a public reaction that would undermine its ultimate authority. So I think the court is sensitive to public opinion, and so in that sense, I say that would be a control over its independence.
Lawyer and former law clerk at the Supreme Court of Canada, Anna Maria Enenjor, says a strong, independent Supreme Court is necessary for democracy.
What independence, judicial independence is the ability of judges to make decisions based on what is right without fear or consequence for themselves, for their jobs, for their security, for their family.
Meanwhile, political science professor Robert Schertzer says judicial independence protects citizens and politicians, and that without this protection, rights and politics itself are under threat.
It is the body that we can turn to in our democracy when elected officials or governments are either doing something that we think are not in our interests, or for themselves when they conflict. So in the institutions of government in a democracy, it's for us an important bulwark for our rights and for the rights of our governments to do what we elected them to do.
Author and law professor Constance Backhouse says that while the court is independent, some politicians do not refrain from attacking the court, which may undermine the court's independence.
I don't think we've gone too deeply down that road yet, but I see caution ahead. Quite regularly, courts will make decisions that our politicians don't like. And increasingly, I hear them saying disdainfully that the judge should be removed or that that was a crazy decision. I think that is disrespectful. I think there's lots of room to disagree with a judge's decision, and there are lots of people who are able to speak like that, and many of them do, including myself. But I think if you represent the legislature, it is a bit frightening to see them being so disrespectful of the courts.
The Supreme Court of Canada has served Canadians for 150 years, and through its independence is able to hear and decide cases without fear of retribution. Legal experts say this is key as the Supreme Court defines its path forward. Coming up in our next episodes, we bring you more on the role of the court.
It has a role that's somewhat like a parent. That, when parties are disagreeing or have a significant conflict, someone has to render a decision. And so that's largely what our Supreme Court does in our system of government.
Its inner workings.
The court needs as much as possible consensus because the consensus gives clarity. The rest of the country is taking its lead from the decisions of the court.
And we look back at its history. All that on the next installments of CPAC's Inside the Supreme Court of Canada, 150 years of the highest court in the land.